Get ready. 3 seconds. 2 seconds. Start. This revision filed by the informant petitioner is directed against the judgment and order dated 3/8/2009 passed by the learned additional session judge in session case number 133/2008, acquitting the accused opposite party number 2, namely Himanta, of the charges which were framed against him under section 376 and 417 of the Indian Penal Code. I have heard learned counsel for the informant petitioner and learned counsel for the accused opposite party. I have also heard learned additional public prosecutor Assam. The case of the prosecution may in brief be described thus: the informant was in love with the accused, who promised to marry the informant, and on 14/1/2002, when the members of the family of the informant were away from their house, the accused, by giving assurance to marry the informant, induced her to have sexual intercourse with him. Believing that the accused were sincere in making the promise, the informant allowed the accused to have sexual intercourse with her on several occasions. As a result of the sexual intercourse which the accused had with the informant, she became pregnant, and when the informant gave the information as regards her pregnancy to the accused initially repeated his promise that he would marry her, and having repeated similar promises to other relatives of the informant and her co-villagers, the accused did not eventually marry the informant, whereupon the informant lodged a written information with the police station with regard to what the accused had done, treating the said written information as first information report. Police station case number 78/2002 under section 376/406/493 IPC was registered against the accused, and on completion of the investigation, police laid charge sheet against the accused under section 376/493 IPC. During trial on charges under section 376 and 417 IPC having been framed against the accused, he pleaded not guilty thereto. In support of their case, prosecution examined altogether 12 witnesses, including the informant. The accused was then examined under section 313 CRPC, and in his examination aforementioned, the accused denied that he had committed the offences which were alleged to have been committed by him. The case of the defense being that of total denial, no evidence was however adduced by the defense. On having found the accused not guilty of the offences charges with, the learned trial court acquitted the accused accordingly. Aggrieved by the acquittal of the accused, the informant, as indicated above, has come to this court with the present revision. While considering the present revision, which has arisen out of judgment of acquittal of an accused, it needs to be borne in mind that this court cannot convert, while exercising its revisional jurisdiction, an order of acquittal into an order of court has not taken into account any material aspect of evidence which had been laid before it and which it ought to have taken into account, or that the learned trial judge has misread or mistrued any pieces of evidence, or taken into account an aspect which was wholly irrelevant or inadmissible in law, and that such acts or omissions on the part of the learned trial judge resulted into acquittal of the accused, the revisional court can set aside the acquittal and remand the matter to the trial court to arrive at a decision in accordance with law. Stop.